Very happy Wednesday to you and welcome to our Elville webinar series. Our topic and objective today is understanding the uses and purposes of irrevocable trusts in 2024. And your presenter is our very own Managing Principal and Lead Attorney, Stephen Elville. And I'm Jeff Stauffer, Community Relations Director with the firm, and I'll be your moderator for today. And a few housekeeping items as we have some new attendees here. Welcome to everyone. We always encourage your general questions, so please pose them throughout and we'll pause periodically to address them. And they always add a lot of value to the presentation, so thanks in advance. And yesterday afternoon by email, you received the presentation slides that Steve is going to be referencing, and they're also available in the section marked handouts on your screen to download at this time. We have many professionals on today's webinar, so thanks for being here. And most everyone can receive 1.5 continuing education hours for attending. So if I don't have your accreditation or an ID number yet and you like those credits, please send that to me and I'll get those approved and certificates out very quickly. Everyone will also receive a post-webinar feedback email right after the presentation, so please make sure that you fill this very important yet brief survey out, and we always appreciate and value all the comments that you have to share with us. And a question for you: have you achieved your planning goals, or have those goals shifted since you last looked at your planning? And here at Elville Associates, we want to always be a resource to you and your family for your planning needs. It's starting from scratch, reviewing documents, an administration matter, whatever it may be. Steve and his team are here to advise and counsel you every step of the way. So I'd like to offer Steve and the firm a brief introduction, then we're going to jump right in. We have a lot to cover. And one more question: what makes Elville Associates different from all the other attorneys that you may have worked with in the past? We're going to try to answer that in the next 75 minutes, and hopefully that will become very clear to you. So you should be able to see my screen here. Elville, I jumped the gun here a little bit. There we go. Elville Associates, been around since 2010, founded in Columbia by Stephen Elville. And we have many different practice areas that we focus on here at the firm on a daily basis, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship, different types of litigation along with that, and tax planning and asset protection. We have 9 attorneys, 12 staff members in 3 locations, including our new Rockville office, which is doing really well down there off of Rockville Pike. Hope you go visit that soon. Our mission, as it always has been and will be, is to provide practical solutions to our clients' needs through counseling, client education, and the use of superior legal technical knowledge. And we focus on education a lot here, as you know, and that's one reason you're here. We do it in many different ways, though, and it's through our planning processes with our clients. We have different programs to suit all families and individuals here at the firm. We also offer many educational webinars and workshops in the communities that we serve each year. We just had a very large webinar with the ARC of Frederick County and the ARC Northern Chesapeake region last night. It was a lot of fun and a lot of great information shared on that presentation by Steve. And also we have an accredited client care program here at the firm, which is growing every day. One of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. And each day, we also work with the ideals of client education, collaboration, and compassion, and also work to be very comprehensive with every client here at the firm. Just a bit about Steve. His work as an attorney for the past 24, maybe 25 years at this point has been centered in elder law, special needs planning, and estate planning. A member of many different national professional and membership organizations, including the National Academy of Elder Law Attorneys, Wealth Council, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Steve works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and leading edge legal technical knowledge. And Steve is a very busy speaker, presenting at many webinars, workshops for businesses and their employees, different conferences, continuing education events each year. And lastly, Steve was named to the Maryland Super Lawyers list for a 9th time, an 8th consecutive year in 2024, and we'll see what 2025 has to bring. I'm pretty confident though. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization that Steve founded in 2014. I am very fortunate to be part of it. There's a lot of great work that we do in the communities that we serve for student musicians and different music programs that are in need, and there's a lot of them out there, and we could use your support. If you'd like to learn more about the Elville Center, please reach out to me, and I'd be very happy to share our story with you. But for now, we're going to talk about irrevocable trusts and what they are and what their purposes are. And am I right, Steve? There's a lot of irrevocable trusts out there, aren't there?
There sure are, Jeff. And this list this morning that we're going to go through is not comprehensive. It's not all-encompassing. There are certainly other trusts other than these that we're going to talk about, but generally we're going to hit on the subject hard. And thank you, Jeff, for that wonderful introduction. And
Pleasure.
I'm getting my slide situated here, Jeff. And we are going to get started. Good morning, everyone. And what a beautiful day here in Maryland, if you're here in Maryland right now. I commented yesterday, I've never seen such a beautiful fall with all the colors and the leaves still hanging on. So we are truly blessed coming into the holiday season. I'm wishing everyone on this webinar this morning a happy holiday season ahead. And my favorite holiday, of course, is Thanksgiving. But all of the holiday season coming up, I hope you have a blessed holiday with your family and friends and loved ones. Today, we're going to begin on time, which we did. We're going to end on time. We know that your time is very valuable and you're spending your time with us on a Wednesday morning. And I feel privileged to be with you. We could not do this without you. So welcome to our special guests, clients, friends, family, loved ones, advisors, CPAs, and others. Welcome. And today we're going to try to give you something of substance with a lot of information coming at you. And you're going to take this information, beginning kind of where you are. Where are you right now with your planning? As Jeff mentioned, you have a particular reason why you're here. It could be for continuing education. It could be that you have a specific need. And that's what I want to talk about before we launch into all of this very dense information. I asked myself, yes, Jeff.
You mind if I pause you there for just a second? Your voice sounds great. Your camera is lagging a bit. Do you think a change of venue may be appropriate, or some other option to get that camera going?
Could be. I hate to do that, but if you think that would be a good idea, and I will do that. So it could be that we have a connectivity problem here. Would you like me to rejoin, Jeff, and then try to do that again, or just relocate?
Yeah, let's try to maybe rejoin first and then see how that goes.
All right, let's see what happens here. I apologize. Let me do that. I'll be right back. Jeff, I apologize. It says that I'm still connected, so I'm really going to try to disconnect.
Okay. There we go. Thanks for your patience, everybody. Want to get a good connectivity going there with Steve. Thought it was appropriate to jump in there before he dove into the information. But a busy day here this morning at the firm, and taking care of clients and offering educational presentations, and feels like it should be a little later in the week than Wednesday. Wherever you are, I hope you're having a good day. We just had there's Steve.
Hi, Jeff, I'm reconnected. And I have a feeling this is going to be better, I hope.
Seems like so far so good, Steve.
All right.
Would you
So
like
if
me
you can
to
give me,
send you the presentation rights again?
okay, Jeff, we will hope for the best. Hopefully you can see my screen.
Okay, I can.
Okay, Jeff, thank you very much. So apologies to everyone. Hopefully my camera will not be lagging behind. So where we were is we were talking about what we're getting ready to do today, which is unraveling a lot of information about trusts, irrevocable trusts. But I asked myself prior to this presentation, I asked myself, what is the real purpose of this presentation? I've given it so many times, and it's a lot of general information about irrevocable trusts, which is very, very valuable, but it's very general. So other than educating ourselves about all of these trusts that are out there, what is the real substantive purpose for those who might be seeking information about trusts for a specific purpose? And that is why I'm going to say at the outset, remember that irrevocable trusts are a very complicated set of subjects, but I want to just say if we could bring it down to it down to size, what is it really all about? Well, it's all about accomplishing a specific purpose. So an irrevocable trust, by and large, is a trust that usually accomplishes a special set of purposes. So I think if that's what you will come into this, if you're a non-advisor here today, or maybe you are an advisor and you have clients with specific needs, that's what I really hope that you will be able to take away today, is something that will be substantive about a specific purpose or a specific goal that you're trying to accomplish. So Jeff, I hope the audio and the connection are better. I'm going to go ahead and move ahead. Just let you tell me if we're doing a little better.
Steve, how about if we do this? The camera's still lagging a bit behind. What would you say if I were to pull the slides up on my end?
Well, that'll be fine, Jeff. That'll be fine. Why don't you
It's going to take me just a second, and then we'll get right on track here. 1 second.
Alrighty.
I need to send that to myself outside of our cloud environment here, and then jump in there. Right, almost there.
While we're waiting for the presentation, Jeff, I'll just go ahead and say that for those of you who are not familiar, we are awaiting a 2025 year where we're going to have an estate tax exemption of 13,990,000. So the new number for 2025, for those of you who are not familiar, is 13,990,000, and this will be relative to our discussion.
Steve,
all right,
can
Jeff,
you see that?
Yes, I can. It looks like we're ready to go. All right, so what we are going to do today, thank you for your patience, is we're going to give this November perspective on estate planning in 2024. And as I just mentioned, what we're getting ready to anticipate in 2025. Why clients should care about irrevocable trusts. We've kind of talked about that a little bit already. What is the difference between a revocable trust and an irrevocable trust? And what are the most common trusts, although this list is not inclusive, all inclusive, what are the most common trusts in 2024? All right, Jeff, let's go to the next slide. Okay, so other objectives obviously are what are the uses and objectives of these trusts, and that's what I want you to really focus on today is so you can get something out of this, anything that is relative to a special purpose of yours, or if you're an advisor, the special purposes of some of your clients. That's what I really want you to focus on. Take notes on your pad, your tablet, your Android, whatever it may be. The taxation of irrevocable trust, we're going to talk about that very big subject very briefly, and I'm going to talk about perhaps the most important thing in estate planning today, in my opinion, is the need for flexibility and what to do with older trusts and what we should do in new trusts as well. All right, Jeff. So we have a continuing legislative stasis in some ways. Now we have a new red wave. We've just had the election, and we didn't know if it was going to be blue or red, and it turns out it's red. And no matter what side of the political aisle you may be on, from an estate planning perspective, we are looking at estate tax exemptions that are going to probably remain high, but we have a potential reduction in the estate tax exemptions. For those of you who know or didn't know that, by 2026, we have a reduction that's going to come down by the expiration of the American Tax Relief Act. We're going to have a reduction to about somewhere between 7.2 million and 7.5 million per person. This is going to be the exemption on the federal level. But right now, the exemption is 13,610,000 per person. We still have portability, which is another subject. We always have this upcoming 2025 inflation adjusted number of 13,990,000. The cost basis adjustment at death survives. The maximum tax rates remain unchanged. The potential Harris administration, which did not happen, they were proposing a $3.5 million estate tax exemption down to a 2009 level. They were proposing a 39.6% maximum income tax rate. And also they were proposing that there would be a return to a 55% estate tax from the current 40% rate. But none of that is probably going to happen at this point, and we may be looking at a situation where the estate tax exemptions will not come down in 2026. The best thing to do is to remain open and have both eyes open, of course, and a wait and see approach. With that said, those of you who have significant assets or advisors who have clients with very significant assets, we may still want to use those exemption amounts now before a potential of them being reduced. The use of grantor trusts, where the grantor pays the tax, and those could be as very simple as a revocable trust versus a complex trust. Those trusts, those grantor trusts, the use of those trusts remains unchanged, and the estate and gift tax rates remain unchanged right now. So a very, very favorable time to be doing estate planning, doing estate tax planning, gift tax planning, an unbelievable time to be able to continue to do that under our current laws. All right, Jeff, let's go to the next slide. We have continuing opportunities, as I just mentioned. We have opportunities to get ahead of these potential changes. There is a little bit of time pressure now, not as much as there was maybe a week ago if there had been a blue wave. Again, we have unprecedented exemption amounts, unprecedented opportunities with grantor trusts. For those of you who are not familiar with the ins and outs of grantor trusts, I'm happy to meet with you on an individual basis to discuss that. Life insurance as a tool has never been as needed, in my opinion, as it is right now. Potential income tax ramifications of the Secure Act and its effect on retirement plan distributions to children and grandchildren. The potential for the estate tax exemptions coming down. Never been a better time to talk about life insurance. So what is the difference between a revocable trust and an irrevocable trust? Well, for those of you who are not familiar, a revocable trust is merely an alternative to a will. It's a substitute. That's all it is. It's not magical. It's not complicated. It is a substitute or alternative for a will. It does not protect assets. It does not provide tax savings in and of itself. It can be changed or terminated by the grantor. That's why it's the most simple of grantor trusts. The grantor pays the income tax, and Uncle Sam ignores this, but it avoids probate if it is properly funded and properly aligned with assets. All right, Jeff, let's go to the next slide. An irrevocable trust, as I mentioned at the outset, is one that I would say is created for a special purpose. Now, there's all kinds of trusts, which we're going to talk about today, but this is the best way to get your mind around this if you are a lay person. A trust with a special purpose. It avoids probate if it's properly funded with assets. It can provide asset protection for children and other beneficiaries. It can be created at life or at death, which we're going to find out. It may be a grantor trust. It may be a grantor trust like a life insurance trust. And it may be a non-grantor trust, like a trust that's created at death for one of your children. And it could remove assets from the taxable estate, and not only do that, but the assets continue to grow tax-free. So it can provide all kinds of advantages, estate tax-wise and income tax-oriented advantages. So the most common trusts, let's run through this list. We're going to get into more depth on each one of these. So irrevocable spendthrift trusts created at death. Boy, that is a mouthful. Irrevocable trusts at death, the kind that I just mentioned, the kind of trust you would create for a grandchild or a child of yours, because you want to provide asset protection to them. Gifting trusts, you want to provide gifts during your life. So you want a vehicle to make those gifts into. Life insurance trusts to remove life insurance proceeds from the taxable estate. Spousal trusts, we might call this a lifetime access trust. This is a trust where it is used to give large gifts to each spouse to remove the amount of those gifts from the estate. Those of you who are familiar with marital trusts and non-marital trusts, marital trust being a type of marital disposition, and a non-marital trust, which is a bypass trust. A spousal lifetime access trust is just a fancy lifetime bypass trust. Charitable trusts, you might have charitable purposes, charitable intent. Medicaid trusts, a Medicaid asset protection trust versus a veterans trust, a trust that might be used to shield assets from long-term care but provide for the ability to obtain a tax-free income. I just mentioned the marital trust and bypass trust. Jeff, we'll go to the next slide. A grantor retained annuity trust, which is a way of being able to piecemeal assets outside of the estate without it being able to be built up. Special needs trust, we know that many of our disabled loved ones need these types of trusts. A minors trust or an education trust. Dynasty trust, or what we might call dynastical trust. These are trusts that will last down the bloodline through generations, and they have certain characteristics. Domestic asset protection trusts, such as trusts that can be established in places like Delaware, Nevada, Alaska, South Dakota, and other asset protection jurisdictions. Special power of appointment trust. These are a certain type of asset protection trust. Community property trusts in several states. Property could be put into a trust in a state, even though our state is not a community property state. We can still use the advantages of a community property state. Jeff, let's go to the next slide. A qualified domestic trust. This is where we have a spouse who is not a U.S. citizen. A qualified personal residence trust. This is a trust where you might take a second residence and put that into a trust to try to discount the value of someone's estate. Crummy trusts, and this is a little bit funny, but this is the ability to be able to use the annual exclusion gift. We're going to talk about this. A quiet trust. Well, Maryland doesn't have that, but Delaware does, where someone is not entitled to information about the trust. And a standalone retirement plan trust and variations of that trust. All right, Jeff, so we've kind of gone through this litany, and now let's get into spendthrift trusts at death. We're going to try to be efficient. Jeff, if you have any questions that pop up from listeners, viewers, please let me know and I'll stop. So a spendthrift trust at death could be a trust for a spouse, could be a trust for a child, a grandchild, or others. And it can be under a will, it can be under a revocable trust, or it can be emanating from an irrevocable trust. So a good example of this would be the marital trust. Assets are passing to a surviving spouse by the marital deduction, but they are inside of a trust, giving that trust asset protection for the surviving spouse, plus remarriage protection and all of those types of goals. A bypass trust or a non-marital trust is another trust created at death. So when someone passes away and creates these kinds of trusts, look at the third bullet point, a trust for a child or grandchild. These kinds of trusts are protecting from the claims of general creditors, bankruptcy, divorce, and all of those car accidents, all of those kinds of things. These trusts protect from that. Now, these trusts do not protect from child support claims, alimony claims, and so forth, unless the trust is in Nevada. That's the one exception. But those public policy exceptions exist in almost all other states. This trust is a non-grantor trust, meaning it pays its own tax, and that is the subject unto itself, which we're going to very briefly touch on later. But remember, this gets everybody mixed up. It even gets lawyers mixed up. Grantor trust versus non-grantor trust. Remember, as we're going to talk about in a few minutes, a trust that is a non-grantor trust is a trust that pays its own tax, and that situation has to be dealt with carefully. All right, Jeff, let's go to the next slide. A lifetime gifting trust is simply a trust where you or a client of yours or a friend of yours, or you might be giving a gift to a child or grandchild, and you want that to be in a trust. Now, a lifetime gifting trust could also be more complex than that. It could be a lifetime marital trust. Now, you'll notice the acronym QTIP, Qualified Terminal Interest Property, okay? This is a trust that is very much underused in places like Maryland. Even though Maryland is not an asset protection state, so to speak, through the use of something like a lifetime marital trust, where one wealthier spouse makes a gift to a trust for the other spouse, or the other spouse and for the other spouse, that can be a very, very powerful asset protection tool in places like Maryland. So a grandchild's trust, an education trust, these are lifetime trusts where you or your client makes gifts to them. A charitable trust is a lifetime trust where a trust is given a gift. That trust has low basis assets in it that are sold, and those low basis assets are sold without income tax and capital gain. So that is a tremendous advantage for that kind of trust. A dynasty trust, a gifting trust could be a dynastical trust that lasts for generations. And these trusts can be, and depending on what kind, these trusts can either be grantor trusts or non-grantor trusts for income tax purposes, depending on what it is that we are creating. I will just say one more thing, Jeff, before we go on. If we could go back to the other slide. The one thing that I want to talk about here about gifting trusts is that if it is a grantor trust, let's say that we simply have a gifting trust and we want to make sure that it's a grantor trust. Well, what does that mean? It means that the grantor is making gifts to this trust, but they're going to continue to pay the tax. So fortunately, throughout all of the political wins that we've had over the last 20 to 25 years, we still have the advantage of the grantor trust rules in IRC 671 through 679. And through the use of these rules, we can have a situation where not only can the grantor make a gift and pay the tax, but by doing so, continue to make, in essence, continuing gifts to the trust by paying the income tax. Okay, Jeff, let's go to the next slide now, which is the use of life insurance trusts. So life insurance trusts have their, I guess, seasons. At least it seems like that. In my opinion, it's always a good season for a life insurance trust, depending on what the goals of the person are. It removes life insurance from the estate of the grantor and the insured. And it also can remove the assets from a surviving spouse's estate. So if we are using an ILET, a life insurance trust, we can use a first to die ILET or a second to die ILET. Many of you are dealing with situations now where we might need to use second to die insurance for reasons other than just estate tax. Tremendous taxation of IRA assets where parents may want to make sure their child or children are not hurt by that accelerated income tax. So it provides control, it provides for asset protection for the beneficiaries. It can be used to leverage gifts. So let's talk about that. someone who wants to fund a life insurance policy, a life insurance trust, they can make tremendous gifts into this trust up to certain limits, and they can do that and thereby remove the assets from their estate, not only just the life insurance proceeds itself from the estate, but remove the other gifted assets out of their estate. So those of you who are somewhat familiar with this, you're getting what I'm saying. For those of you who are not familiar with this, just know that life insurance is going to be added to the value of your taxable estate, meaning the value of the life insurance itself, unless it is put into a life insurance trust. If it is put into the life insurance trust from inception, it will be excluded from your tax or your client's taxable estate. If it is not included as owned by the trust and purchased by the trust at the inception, then existing life insurance will have to go into the trust and be wading through a 3-year exclusionary period. So this is best used to deal with estate tax, future growth, the Secure Act, and if there was a situation where there was a loss and step-up in basis. So this is usually created as a grantor trust for income tax purposes. Let's go to the next slide, Jeff. And I'll just say, as we're trying to move along here in very expeditious fashion, I see tremendous uses for life insurance trusts in 2024 and 2025. And of course, we're in this wait and see approach, or wait and see period, where we're going to see what happens to the exemption amounts. But if the Republican majority, let's say, does not extend these tax exemptions, we're going to have many, many situations where, in my opinion, people are going to need life insurance and life insurance trusts to deal with the wealth creation in the country versus the lowered exemption amounts if those actually happen in 2026. A spousal lifetime access trust is a fancy bypass trust. It's a lifetime bypass trust versus a lifetime Q-tip trust or lifetime marital trust. So what is a spousal lifetime access trust? So estate planners love acronyms. Uncle Sam loves acronyms. Well, this acronym is SLAT, S-L-A-T. So for those of you who are not familiar with this, if you are a wealthy spouse or a wealthy individual, but generally a wealthy spouse, you can make a large gift. And when I say large, I'm talking about a large gift that would approach your exemption amount, $13,610,000. The idea is to make a gift that would be for the benefit of your spouse or your spouse and children, and you would be using your exemption amount now before it potentially goes away or potentially is getting reduced. So this concept is, I'm going to lock in the use of my exemption before it goes away. If you have excess assets up to 27 million or more, meaning 2 exemption amounts, the other spouse would make another gift, not exactly at the same time, but make another gift, perhaps into a slightly different trust, so we avoid the reciprocal trust rules. And in this way, a couple uses their exemption amount. Now, for those of you who are not married or advisors on this webinar who are dealing with single people who have large assets, this could be a strategy, not necessarily a SLAT, but the same kind of strategy could be a completed gift into a trust, something like a Delaware trust, for example. There could be a use of a trust, even for a single person, to make a large gift and remove assets from their estate. And that person can still be subject to a certain adjustments in the drafting. That person could still be a beneficiary of that gifted asset. So it's kind of hard to believe, but through these trusts, wealthy individuals can use their exemptions before these exemptions possibly go away. So these trusts are generally, at least with the SLAT, this trust is drafted as a grantor trust. Now, before we go to the next slide, think about that. Large amounts of assets going into an irrevocable trust for the benefit of a spouse or spouse and children. The grantor continues to be able to pay the income tax the way they always did, because the trust income is taxed to the grantor. And now whatever that gift was, if it was 10 million, 12 million, whatever that gift is, it now grows, let's say 20 million before the person passes away. that excess 20 million or that excess 5 million, whatever it is, escapes estate tax. So there is no estate tax on the growth of that asset within that slat. So it's a tremendously powerful approach. And if you have not gotten your mind around this, this is something that you probably should be aware of, especially if you are an advisor on this webinar. All right, Jeff, let's go to the next slide. Charitable remainder trust. So this is one of the things that Uncle Sam has put out there for all of us for many, many years without much variation at all. So this is embedded in the IRS code. Charitable remainder trusts are exactly what I mentioned earlier. They are vehicles to be able to put low basis assets. So if you have low basis real estate, low basis stock, it doesn't have to be low basis, but if you have low basis assets and you're charitably inclined, your assets can be transferred to this trust. You can then sell the assets inside of the trust with no capital gain. And you'll notice that it can be for a number of years or a lifetime. And it has a lifetime beneficiary, an income beneficiary, which is you, or it's you and your spouse, or it's you and your spouse and children. And of course, the more income beneficiaries there are, and depending on their ages, the lesser the remainder. So the remainder interest is going to go to charity. And of course, this is, again, for someone with charitable intent. It is a tool sometimes to deal with the Secure Act on a rare basis, but this is for someone who really wants to do good in the world. They are not going to use a donor advice fund. They're going to use a full-blown charitable remainder trust. They get a current income tax deduction, and there will be lifetime income to the beneficiaries. It's a wonderful tool. It is drafted as a non-grantor trust for income tax purposes. So these charitable remainder trusts remain a powerful tool. All right, Jeff, let's go to the next slide.
Okay, one question briefly, Steve, from Ms. Jelks. And the question is, are annuities in the category of life insurance trusts?
Well, that's a great question. Annuities are going to be taxable within your taxable estate, the value of that annuity. To my knowledge, that's a great question. I mean, certainly annuities are very close to being life insurance products. To my knowledge, I've never seen an irrevocable life insurance trust used for an annuity, and I'm not quite sure that that is actually something that could work. So if there's someone on the webinar who's more gifted in this particular area to understand that esoteric kind of question, please speak up. But to my knowledge, annuities would not be treated the same way. That's to my knowledge. But I could certainly look at that offline. That's a great question. Okay, Jeff, let's talk about Medicaid trusts and veterans trusts. So a Medicaid trust is a hybrid irrevocable trust. So let's talk about this for just a moment. In the old days, when I was a young attorney, there were people who wanted to divest their assets and save assets for their children. Keep nursing homes or Medicaid from the Medicaid system, I should say, from placing a lien against real estate or other assets. And of course, that desire and that goal still happens today. But back then, there weren't any sophisticated methods of being able to deal with this. So people would divest assets, or they would divest assets in an irrevocable trust with none of these features that I'm getting ready to describe. So this is a popular tool now, and I would say arguably is one of the most powerful tools in estate planning today, whether someone is really planning for nursing home asset protection, long-term care asset protection or not. This is also a tool that some moderately wealthy people would use just to simply gift assets and use the advantages of this particular kind of trust. So what we're doing in this particular situation is a person is gifting assets to an irrevocable trust without giving up total control. So they retain the power to change beneficiaries. They retain the power to change trustees, but they still get a step up in basis at death. So they don't lose that if that trust is properly drafted. The trust assets that they transferred, which are usually a home or other securities or cash, those assets are for the benefit of the children, let's say. But the children could have creditors, but those creditors of potential problems that the child might have, like divorcing spouses and so forth, creditors of the beneficiaries cannot get the assets of the Medicaid trust because it's protected by a spendthrift provision. But yet the grantor of the trust, who really can't be a beneficiary, they can, through the use of their lifetime beneficiaries, they can get assets out of the trust if they are so needed after the gift. So this is a way where we're achieving step up in basis. We're getting the assets out of the name of the grantor or grantors. We are protecting those assets after 60 months, the Medicaid look period. We are protecting them. Now, veterans trusts are similar, except they are drafted in a certain way that makes sure there's not a lot of income being generated in the name of the veteran, because veterans benefits are income sensitive. So this is a similar trust designed to get assets out of the name of the veteran and start the period for veterans benefits, or instantly qualify the veteran for veterans benefits, which is an aid and attendance benefit, which is a tax-free income for that veteran. So sometimes when we are doing veterans benefit planning, we are also hitting 2 or 3 birds with one stone and getting the assets out of the name of the person or couple for Medicaid purposes as well. So this is very confusing. The Medicaid rules and the VA rules oftentimes would bump heads in the past. But as of 2018, the VA rules were changed and modified, and we don't have so much head bumping now, although we still do have some of that. And this is just a question of counseling and whether there's a veteran who's qualified for veterans benefits, or whether we are just divesting assets for Medicaid purposes. So we get a step up in basis, we get some control for the grantor. The grantor gets to live in the property that they transfer to the Medicaid trust. They have a life estate there and they don't have to pay rent. There's a tremendous power in these trusts, but they have to be for the right person. It is not a one size fits all. There has to be family harmony, and there has to be a real clear goal on the part of the person that they want to protect assets for long-term care purposes. All right, Jeff, let's go to the next slide. A marital trust. So a marital trust is simply a trust that's going to be for the benefit of spouses who survive. So when spouses are doing planning, they are going to decide basically, are we leaving assets outright to one another, or are we going to leave assets in a marital trust for one another? So to make a long story short, with lots of exemption amounts that's still available to everyone, the 13 million and going up next year, I would say about 80% or more of people in this country should use the marital trust or the marital deduction kind of planning. So if they use a marital trust, what are they doing? Well, it does get a step up in basis as if someone had died and there was no trust, so it still gets a step up in basis. There is a second step up in basis when the surviving spouse lives many years later, many years beyond the death of the first spouse. The survivor has asset protection in that trust. So remember, people who are married, they have at least basic asset protection as spouses, tenants by the entireties. But now when one spouse dies, the survivor does not have that tenants by the entireties protection. So this may be a reason to use a marital trust. But also, what if the surviving spouse remarries? So the first spouse to die says, I want some control over those assets, that those assets go down after your death, my surviving spouse's death, it goes down to my children the way I want, or my grandchildren. So this is a powerful tool for control, still qualifying for the unlimited marital deduction, and protecting from the issues associated with remarriage. Now, if someone uses a marital trust, we have to make a Q-tip election after the death of the first spouse. And of course, that's not going to be a big deal because maybe that couple is going to be making the portability election as well. And so they're going to make sure that they're porting the exemption amount of their deceased spouse. So we're hitting 2 birds with one stone when they make that election on Form 706, and in Maryland to be making the portability election, because unlike DC, Maryland does have state portability. So choosing the marital trust, if it's appropriate for that couple, is not going to be that much different than just choosing portability. because there would still be an estate tax return required anyway to do that. So a marital trust is a non-grantor trust for purposes of income tax. Jeff, let's keep going. I'm looking at my watch and we are about, I guess, a little bit more than halfway through. A bypass trust is very similar to a marital trust, but the marital trust can only be for the benefit of the surviving spouse. With a bypass trust, we are going to have a trust that's for the surviving spouse, but also for children. So this is a popular tool, but it's not going to be appropriate for most people, in my opinion, because it does not get a second step up in basis, but it could be depending on what the goal is of that couple. So again, it protects the survivor from creditors. It does have certain tax advantages. So for people who are not doing slat planning, they're not getting rid of their assets and using their exemptions, but they have large estates, it could be that bypass trust planning is still appropriate. But again, for most people who have less than 2 exemption amounts, the 27 million or less, the numbers are going to generally show that the marital trust planning is the better way to go. But again, the bypass trust planning is something we used to see a lot of in older estate plans. It still is appropriate, but we have to look at the goal. We have to look at the size of the assets. And this is what I'm going to say here. It's a non-grantor trust for income tax purposes. It would be only a grantor trust for income tax purposes if it were a slat. But this example with a bypass trust is a trust at death on the death of the first spouse. All right, Jeff, let's go to the next slide. A grantor retained annuity trust is a strategy. It is not going to be a way to remove large amounts or bulk amounts from the estate of a person who is subject to estate tax, but it is a way to transfer assets into a trust and achieve a certain rate of return, which we certainly are seeing in the markets over the last several years. And if it exceeds, if the return of the trust exceeds the IRS 7520 rate, then the excess amount is removed from the person's taxable estate. So for those of you who are dealing with clients that have a lot of wealth that they've created, and the amounts of income that they have and the growth of their assets just continues to proliferate, a way to remove that growth from their estate could be the use of a grantor retained annuity trust. All right, Jeff, let's go back to the next slide. A minor's trust, we're only going to spend a minute on this. This is a trust that's still out there under IRC 2503C. It's not used very much, so I'm not going to spend very much time on it. This trust kind of emanated prior to the advent of 529 plans and other planning tools for young people, but it is still out there, a minor's trust. All right, Jeff, let's go to the next slide. An education trust. Many of you or your clients are very passionate about education. Now, of course, we've got the advantages of a 529 plan, which many of you are experts on, but an education trust could be something that accomplishes educational goals down the line in perpetuity. It can be, like I said here in this slide, multi-generational, but it can also have a philanthropic approach or use, and the tax treatment of these kinds of trusts depends on the kind of design that we do. So lots of wonderful things can happen here with the passion that you may have for education for your children, grandchildren, and others down the line, or beyond that. So education trusts are available. All right, Jeff? All right, special needs trusts. So Elville and Associates has been very, very proud and privileged to be involved in the special needs community for many years. So the special needs trust is a broad term of art. There are 2 types. One is the supplemental needs trust, and we'll call that a third-party supplemental needs trust. This is a thing that gets lawyers mixed up. It gets the public mixed up. It gets advisors mixed up. So let's get our terminology straight. The bread and butter of estate planning for people with a loved one with disabilities is a third-party supplemental needs trust. This is a trust where the grantor of the trust is the third party, the parents, the grandparents, or other relatives that create a trust for the benefit of a person with disabilities, and they leave funds or other third parties leave funds into this trust, and that trust is for the benefit of that person with disabilities. It does not affect their public benefits, what we might call means tested benefits. It does not affect that, no matter how much money is in there, and it can be used for their discretionary or supplemental needs. So this is the third party trust. Now that third party trust can be drafted as revocable or irrevocable during the life of the person who creates this. Now the first party trust is where the person with disabilities has received an inheritance that they shouldn't have received, or they have a birth injury and were given an award, an annuity structure or something, or they've had a terrible car accident and they're getting a large settlement. These are the types of trusts that are used and are created through the state and federal law from 1993 that allows the creation of these first party trusts. We would call these trusts generally a D4A trust. And this is under the United States Code 42 USC 1396P D4A. But that is the first kind of first party trust. There's a second kind for those of you who have heard of a pooled trust through the Maryland First Disability Trust or the Arc of Northern Virginia or First Horizons. But again, the difference I want you to take away here is when you are doing estate planning for a loved one with disabilities, we are going to use the third party trust because those assets have no payback to the state once the beneficiary dies, and the assets can go where the grantor wants them to go. The first party trust is more controlled. It has to be for the sole benefit of the person with disabilities, and there is a payback to the state of Maryland, but sometimes we have to use the first party trust no matter what. For example, military veterans who want to leave their pensions to a person with disabilities, their child, can leave it only to a first party trust because of the Pension Act that had to do with military pensions. So this is a very powerful way of dealing with providing for a loved one with disabilities, and it can even be done in routine estate planning where no one has disabilities, but there could be someone down the road that has disabilities. And I just want to say that Maryland law is very favorable to these kinds of trusts, including the new decanting law that addresses the ability to amend or change trusts, and a big emphasis on special needs. All right, Jeff, let's continue. And again, I'm getting a little bit ahead of myself. This will just reiterate what I just said. The third party trust is the most common kind. There's no payback to the state. It's flexible, and you'll see the other references here to the first party trusts. All right, Jeff. Now, a dynasty trust is, or a dynastical trust, or I'm going to give you some terms of art, a generation skipping trust, a bloodline trust. These are multi-generational trusts. These are trusts that are drafted where basically what happens is they stay in trust for perpetuity. And this can be a trust at death. So in other words, you could leave a child or a grandchild a trust at your death that's dynastical, that's designed to last forever, because there is no rule against perpetuities in Maryland, and many states have abolished the rule against perpetuities, meaning that trust can last basically forever, in so many words. Now, with the design of this trust, what you are really doing, what the person is really doing, is they are saying to Uncle Sam, we are going to be taxed, we are the grantors or creators of this trust, we are going to be taxed at our generational level. So when Uncle Sam comes in and assesses whether or not that person has to pay tax, that situation occurs at that generational level, and there's either going to be tax or not. But now when that person leaves the assets down the line to their loved ones, and they have a properly designed dynastical trust, the tax, the estate tax, is forever free. Those assets are forever free of estate tax. Now, Uncle Sam tries to come in and they try to hit with another type of tax called the generation skipping tax. But basically, if a properly designed dynastical or bloodline trust is created, Uncle Sam will tax at the generation of the grantor, but will never be able to tax again for estate tax purposes down the line. So this is how the assets can grow and be frozen in time for estate tax purposes, no matter how much those assets may grow. So this is what we want to think about for people who are generation or multi-generation planning minded. All right, Jeff. All right, Jeff, it looks like we've gone to the next slide. Domestic asset protection trusts. Our neighbors in Delaware have wonderful laws for domestic asset protection. A self-settled trust is something that cannot be done in Maryland. So if someone says to you, well, I want to protect my assets, so I'm just going to take my assets, put it into a trust for my own benefit. Well, that's not going to work in Maryland because that's called a self-settled trust. So there's only a couple of ways that can be done. One of those ways is that first party special needs trust, but generally speaking, in the world of estate planning, that cannot be done in a non-asset protection jurisdiction like Maryland, but it can be done in Delaware. Now, this may afford asset protection. It could be done in Nevada. Now, when I say may afford asset protection, a domestic asset protection trust is not going to be bulletproof. It is not like we can put assets in there and absolutely know that they will never be subject to the claims of creditors. For example, a lot of California residents use Nevada trusts for their asset protection, but even a self-settled trust could be invaded by a creditor. So a self-settled trust on its own is not necessarily going to protect, but it will start putting layers of protection in place. So a third-party trust, okay, like a hybrid domestic asset protection trust, where someone like a spouse creates a slat for someone else, that is going to be very good asset protection. And then there is something called a special power of appointment trust, where a person could create a dynasty trust that has all kinds of levers and controls that have to go through the control of others for that person to be able to benefit from their own assets. So these kinds of things exist. For those of you who are interested in this, there's a lot of good Delaware lawyers to our east, but Elville and Associates deals with a few that we trust, and we can get these kinds of proposals for people who have specific needs for Delaware planning or Nevada planning or other planning in other asset protection jurisdictions. All right, Jeff, let's go to the next slide.
Hey there, Steve. Can we pause for a question?
Yes, please.
Okay, so kind of a multi-layer one here, just maybe some general thoughts. My mom, second to die, put the family house into a trust for my brother during our lifetimes and then for the grandchildren. My brother has lived in the house for 15 years when my parents were alive, and then 5 years after their death, he wants to sell the house. Since the house is owned by the trust, can and should he move the house out of the trust prior to the sale, because the trust cannot claim 121 capital gains exemption? Do the sale proceeds need to go back into the trust? And also, what is his basis? So multi-layer there.
Thank you. Yeah, thank you for that question. I wouldn't be able to give legal advice on a webinar like this. So I would say there's multi-layers to that question. And I would say the best answer I have, just as a high-level answer to that, which is not the specific answers you're looking for that we could actually look at, by the way, but see, when you take assets out of a multi-generational trust like this, that those assets have been shielded from estate tax, and you take those assets out, and of course I don't know the facts of this particular situation other than what is in the question here, you're taking what we call in estate planning, you're squirting the toothpaste out of the tube. And when you do that, you can't get the toothpaste back in. So my initial reaction is, just as an educational response, is that's probably not going to be a very good idea, and that's not really, what was meant to happen there. But I understand your question, and certainly we could look at it in more detail. A community property trust is a trust where we're trying to get the benefits of community property, and I'll give you an example. Maryland is not a community property state, it's a separate property state. But if we look at Texas and we go around the rim to California, Washington, all the way around to Wisconsin, I believe there's about 14 community property states, and there are tremendous tax advantages or income tax advantages in those states where if a couple owns community property, or even a person, I should say, owns community property, doesn't matter which person of the spouses dies first, that community property is going to get a 100% step up in basis, whereas in a separate property state, that would not occur. So what we've got is a 100% step up in basis possibility using community property law. So even if you live in a separate property state like Maryland, if there is a sufficient advantage, meaning a very big advantage of getting a 100% step up in basis in property that otherwise would not have, then we can use community property trusts in states like Alaska, Tennessee, South Dakota. I want to say, Jeff, even Michigan, but don't quote me on that one. And so we have the ability to use these different jurisdictions. All right, Jeff, let's keep going. I know we are already at 11 o'clock. Let's go to the next slide. A qualified domestic trust is basically for a non-citizen surviving spouse. So Uncle Sam does not want our non-citizen surviving spouses to inherit from a U.S. citizen spouse and then be able to run off, so to speak, to their own country, not that they're going to do that necessarily, go back to their home country and escape estate taxation. So this allows the surviving spouse to use the unlimited marital deduction, and Uncle Sam has got some strict controls that we have to put in estate planning documents if we want to give the non-citizen surviving spouse the ability to use the unlimited marital deduction, because if they don't, the rules are rather harsh and they have to jump through hoops to become U.S. citizens if they are not already U.S. citizens. So this is a counseling issue, and it's also a practical issue for people who are married couple with a non-citizen spouse who may survive. So this is something we have to address, and this issue has been around for years and years. Jeff, let's go to the next slide. Yes, so let's keep going there. A qualified personal residence trust, or what we might call a CUPERT, is the ability to take a secondary residence, but it actually could be done for a primary residence as well. And we are going to choose a period, 5, 10, 15, or 20 years. And if you implement this kind of plan where you're gifting a residence or a second home into a CUPERT, you are basically, this is a split interest gift. It's a gift where you're actually using some of your exemption, you're giving away that house or that property at a discounted value to your children. And then if you outlive the period of years required, let's say it was a 10-year CUPERT, then you get you achieve that discount. And that house, which might be worth this much, but you were able to give it away for a lesser amount using your exemption. So this allows you to continue to live in the residence. Unfortunately, you have to pay rent after the term ends for this thing to actually be a valid strategy. So that may or may not make sense in your situation, but CUPERTs are a viable strategy. We're trying to discount the value of an estate if we are using a CUPERT. All right, Jeff, a Crummy trust, Mr. Crummy in the 1960s, he asked Congress, he asked the IRS, he said, I should be able to use my annual exclusion gifts. And by the way, that is currently $18,000 per person per year, apologies. And it's going to be $19,000 next year. So in 2025, it will be $19,000 per person per year. So Mr. Crummy said, I should be able to use this Crummy right to make gifts to a trust where my children and grandchildren, and I don't remember how many, but I think it was 14 or 50, maybe even 17 people. And Mr. Crummy basically won. He litigated against the U.S. tax court, and the tax court says, Mr. Crummy, you are absolutely right. You should be able to use these annual exclusion gifts to get money into that trust, get it out of your taxable estate, as long as you say to the beneficiaries, you have a present right of withdrawal. So this is where the Crummy notice has to be given to beneficiaries who have a right. Does not have to be 30 days, but typically it is. And they receive the notice. And if they're good children and grandchildren, they are going to refuse to act on their right. And then by refusing, that lapses. And now the present interest gift is allowed to go in. And you, or in this case, Mr. Crummy, are allowed to use your annual exclusion gift to fund a trust. So this is the Crummy Trust. We know that we're going to have a stronger, more diligent IRS in the future. We want to make sure that our Crummy trusts are usually not always, but many times used in life insurance trusts. We want to make sure that everything is documented. All right, Jeff, let's go to the next slide, and we're going to try to finish on time. A quiet trust. Maryland has no such thing. So for better or for worse, in your point of view, depending on what your goals are in your family situation, because Maryland provided in 2014 for the Maryland Trust Act, which really very much updated Maryland law with regard to trusts, and Maryland was behind. I'm happy to say that Maryland has done a lot to catch up, and Maryland law is very sound with regard to trusts, decanting, and all of these things. But a quiet trust is not possible. Now, the Maryland Trust Act says that beneficiaries are entitled to notice, they are entitled to information, qualified beneficiaries. So the issue here is you may have a beneficiary that you do not want to have information. You will not be able to accomplish that under Maryland law. We can accomplish that under the laws of other states, such as Delaware. Maryland law seems to indicate that someone other than the beneficiary, let's say a special representative or a special agent, can be given the authority to receive information. But that is deceiving, because that's not really what this is saying. That person is only allowed to receive information and notice, but the beneficiary still has the right to get the information from them. So there is no such thing as a quiet trust in Maryland. Beneficiaries are entitled to information, they're entitled to notice, and they're entitled to all information. And that may or may not be good news for some people who are doing certain kinds of planning. Jeff, let's go to the next slide, and I think we're getting toward the end. A standalone retirement plan trust. So I want to take you back to the pre-2020 world, the pre-Secure Act world, where the stretch IRA, the ability to defer tax until old age and take only required minimum distributions, that world used to exist. Now, what we do is in everyday estate planning here at Elville and Associates, we are creating spendthrift trusts at death for children, grandchildren, and many of those trusts are receiving IRA assets, even though many of the top magazines and financial writers are going to admonish us and say, never, ever leave a retirement plan to an irrevocable trust. Well, that is easy for them to say, but it's not what clients want. Clients want to protect their IRAs from the claims of creditors, because due to a case about 10 or 15 years ago called Clark v. Ramaker, which was a Supreme Court case, retirement plans that we leave to our children, inherited IRAs, are no longer protected from the claims of creditors. So we have the issue of how do we leave IRAs to a trust? So we can leave IRAs to trusts at death for beneficiaries, or we can leave IRAs to a standalone retirement plan trust, a trust that exists strictly to receive IRA assets. Now, when those trusts type like this, a separate trust, a standalone trust receives IRA assets, or a testamentary trust, a trust at death that receives retirement plan assets, we have to figure out how we're going to deal with that. Is it going to be a conduit trust, which means when the IRA money comes in, it automatically is distributed out? Or is it an accumulation trust? It accumulates the assets inside the trust, and we know that's going to trigger a 37% tax. So we're not going to probably do accumulation trust in most cases unless it's a special needs trust or a supplemental needs trust. So let's go back to the conduit, and we're going to end on this, I think. We've got assets coming into that trust, and let's say it's a healthy beneficiary that is not exempt by the Secure Act, and they have to pay tax in 10 years. So when they take 10% out, or whatever they're going to take out that first year, it comes into the trust, and under the conduit, it has to be distributed straight out. So what that means is the beneficiary is going to pay tax at their own rate, and that's desirable. But the problem is, from an asset protection point of view, after 10 years, or whenever the beneficiary takes all the money out of the IRA, there is no more asset protection because all the money is outside the trust. Why? Because we don't want that money to pay 37% tax. So what we can do now is consider, depending on who the beneficiary is, who the trustee is, the needs of the beneficiary. Is it a healthy beneficiary with no issues? we may be able to use a technique that's come about in the last several months or year or so called the BDOT, or the Beneficiary Deemed Owner Trust technique, where assets can remain in the trust longer and that beneficiary can be treated as the owner for income tax purposes. But the standalone retirement plan trust is kind of the ideal vehicle to leave retirement plan assets into, or we can use a basic testamentary trust to leave retirement plan assets into. But no matter what we do to protect retirement plan assets from the claims of creditors, we do have to deal with the income tax issue, and we have to decide what approach we are going to take. Are we going to use this relatively new approach called the BDOT, or are we going to use a conduit? And what is the goal and needs of the client, basically, and what kind of beneficiary do we have? All right, Jeff, let's go to the next slide. We're wrapping up. I know it's 10 after 11. And we are now looking at trust taxation very quickly. So we alluded to this earlier, IRC 671 through 678, or even 679. A revocable trust is a prime example of a grantor trust. And for those of you who are still with me or having their second or third cup of coffee this morning, what is a revocable trust? It's a grantor trust. And what is a grantor trust? A trust that pays its own tax. I don't care how complicated it is. I don't care how complex the trust is. If it's a grantor trust, the thing to remember today, because you're going to get mixed up about this, the grantor pays the tax in a grantor trust. A life insurance trust does not have to be a grantor trust, but is usually drafted as a grantor trust. Whatever income, interest and dividends this life insurance trust creates, the grantor trust is going to pay it. A non-grantor trust is a trust that pays tax itself. So for example, when assets were left to that testamentary trust or to that retirement plan trust, that trust is going to be a non-grantor trust. It's going to have to file a 1041, a trust and estate income tax return. And that income is going to be attributed, in the case of a grantor trust, it's going to be attributed to the grantor, but in a non-grantor trust, that trust is going to be deemed to have $20,000, $30,000, $50,000 worth of income. And now Uncle Sam says, who is going to pay that tax? Because it's a non-grantor trust. Well, 9 times out of 10, the beneficiary is going to pay that tax. So remember, that trust is going to be taxed at 37% at only $15,200 of income. $15,200 of income. So we've got to make sure that we understand carrying out the income tax, carrying out capital gains to the beneficiary, who will claim that income on their own tax return, and that's how we can get around those 37% rates, unless that beneficiary is making a huge amount of money under the Tax Act of 2017, and they're usually not making that much money. So they're going to pay a lesser income tax, and that just brings up the issue of we have to manage trust taxation in a trust where a trust is a spendthrift trust at death, creating its own income, and that income has to be reported and it has to be managed. So this is part of a trustee's duties and responsibilities. It's part of continuing education. It's a part of collaboration with the financial advisor, the CPA, and the attorney, and an educated trustee. All right, Jeff, let's go to the next slide. So flexibility, as we start to wrap up. One of the things we talked about last night in last night's workshop, one of the things that I think is the most important thing in estate planning today is flexibility. Not everybody can build in flexibility because not all family situations are different or the same, but generally speaking, contemporary trusts, new trusts, should have trust protectors, a special fiduciary who can make certain decisions and direct the trustee, generally to remove and replace trustees. They have that power, and they have the power to amend. They also have lots of other trigger powers, let's say, that provide flexibility into the trust. Not required by law, but I strongly recommend that the client recommend or think about trust protectors. The whole discussion about who a trust protector should be is something that would have to be done one-on-one. A special independent trustee could be a person who has powers to decant a trust outside of Maryland. Probably we don't really need to decant outside of Maryland anymore, but there may be circumstances where decanting might be needed in another state, like Delaware or Virginia. Maybe the laws there are more advantageous to a particular situation. I'm going to mention two other things. We have decanting there at the bottom. Decanting is the ability to change or amend a trust in a big way from this form of a trust to this form of a trust. And clients can opt in. They can say, yes, I think that might be desirable, that a trust might need to be changed in the future because the laws changed, and therefore the trust needs to be adjusted. These are generally good ideas once we get our minds around them, but they have to be controlled and understood. Also, there is something called a non-judicial settlement agreement since around 2017, 2018 that can be used. In my opinion, it has its uses, but decanting is, especially the new Maryland law, is very, very nice. And I think it gives people a lot of flexibility, especially in special needs planning. Special fiduciaries, sometimes in domestic asset protection trusts, investment direction advisors, distribution advisors, independent distribution advisors. What this does, it allows a grantor of a irrevocable trust to set in motion a vehicle that will accomplish their purposes, but still allow them to have flexibility. And I would be remiss if I didn't say, if you look at the next to last bullet point, attorneys in fact or agents under a power of attorney, giving them the flexibility to deal with your estate as you get older. Arguably the most important of all these documents. We're talking about very, very complicated issues here, irrevocable trusts of this kind and this kind. But on a foundational, fundamental level, nothing is more important than a very flexible, broad power of attorney document, generally speaking, depending on the goals of the client and the family situation. All right, Jeff, let's go to the next slide as we start to really wrap up. Remember, older trusts usually have none of this built-in flexibility. If I had spoken to you 20 years ago on this subject, we would be sitting here talking about static trusts, trusts that really can't be changed except through common law techniques of everybody agreeing and everybody getting approval under a court, for example. They have no built-in flexibility. But now, through the use of powers and powers of attorney, where your agent could create new trusts or do certain things with trust, trust modification under the terms of the trust itself, the modern terms might provide for this, non-judicial settlement agreement, which I just mentioned, decanting, which I just mentioned, or court modification or reformation, which is the old-fashioned way of doing it, but much more flexibility now, 20 years later, than I used to see as a young lawyer, and I think an extremely advantageous time to be able to know that from a client perspective, clients can put trust in place knowing that throughout the rest of their lives, they can continue to look at the trust and make changes if they need to, or have that flexibility so that they have peace of mind that the trust will work the way they want after their passing. Jeff, let's go to the next slide. So irrevocable trust, as we really wrap up now at almost 11:20, remember that, in my opinion, you should think of an irrevocable trust as a trust with a special purpose. There was a goal. All planning is goal driven. There was a goal. We're moving toward that goal, and here's the vehicle that takes us there. Okay, we understand the risks and the rewards, but it's got a special purpose, satisfying a good or goal or need. It has benefits of protection, generally speaking. It has certain tax attributes. It should have flexibility in the modern world. If we're dealing with older trusts and those trusts don't have any flexibility, we may be able to decant those trusts. We may be able to change them in some way under the law. It has control components for clients and for possibly beneficiaries as well. And your advisory team, meaning the financial advisor, the CPA, the attorney, the life insurance professional, and in some cases in elder law and special needs planning, the aging life care manager or advocate who could be involved would be supportive in the overall planning. All right, Jeff, let's go to the next slide. So we have a lot going on here in this presentation. I would just say we have education is the driving force, but we sure do have a set of laws and a set of national jurisdictions that sure give us a tremendous ride down the road of estate planning. So what we want to do, if you're a professional on this webinar this morning, I want to thank you for being here. We want to give clients the time and space to think about these things, know what their goals are, and if they don't, give them the time to have an epiphany of what their goals are and should be with counseling. Give them the assurance that they can make big decisions but still have flexibility. They can do great planning and still remain in control, or maybe they're going to decide that based on what they see, they're going to keep things simple and they're really not going to do some of this more complex planning. But they need to be aware of the tools that are available to them. And through education and so forth, clients can be apprised of this. We just had our 2024 client event in Columbia on Saturday. I was very gratified that the education we were able to bring and the education I know you believe in, or you wouldn't be on this webinar this morning. This is what not only supports our efforts, but it really drives people, family members, fiduciaries, and brings advisors together in a collaborative setting. So it builds trust, maintains relationships, but maybe perhaps the biggest thing is it facilitates planning that actually works down the road. All right, Jeff, let's go to the next slide, and maybe we're almost at the end. Our path forward is always to suggest that we meet. If you're an advisor on this webinar, I'd like to meet you for lunch and rekindle old relationships, or maybe meet new advisors that are on the call. You are at the forefront today. We want to collaborate with you, support you, help educate you and your clients, and basically facilitate for you. If you have a client, or if you are a person on this webinar today that needs an estate planning update, please feel free to relax. There's nothing to fear. There is an attorney-client relationship when we are sitting together. Everything is confidential, so there's nothing really to fear. We would like to see your current estate planning documents, or advisors. We would like to see the documents of your clients who need updates. We don't charge for that, generally speaking, and we want to help you have a collaborative advisor team. If you're a person on this call who does not have a collaborative team, we want to help you. We want to answer your questions. I thank the people today who raised questions throughout this dense material. Appreciate it. It helps tremendously with our workshop. And in this world today, lots of political winds, lots of all kinds of things going on in the world with our changing environment. We want to take the time to think, give you a time to discuss and be counseled to help you achieve your goals. I want to thank everyone. Please have a wonderful holiday season ahead. Jeff, I'm going to turn it back to you on this beautiful day.
Steve, thank you so much. Lots of really high-level legal education there, and I want to thank Steve for offering this today. I'm not sure there's any other law firms out there that focus presentations on things like irrevocable trusts in this way. So Steve, great job. Thank you. Lots of nice comments from our attendees. Two brief questions, and then we'll jump right off.
Thank you, Jeff. And you may want to go to the next slide, by the way.
Oh, sure. Thank you.
Happy to answer questions.
What states are you licensed to provide client services?
Well, thank you. I'm licensed just in Maryland. We have attorneys at our firm that are licensed in Maryland and the district. We have some attorneys that are licensed, or at least maintaining their license, in New York, and perhaps one other jurisdiction. I'd have to double check that. Thank you for that question. We can work with clients in various jurisdictions because, as you can tell by the presentation, our environment that we're living in is a multi-jurisdictional environment. So in circumstances, certain circumstances, we can help clients in various jurisdictions so long as we have co-counsel in those jurisdictions.
Okay. And last question is, I am trust protector of an irrevocable trust. I believe my only power is removal and replacement of a current trustee. Do I have any say relative to how the trust is invested?
Well, thank you for that. I'd have to look at the trust very carefully, but generally speaking, at a high level, there would not be any power to direct investments unless you had a specific trust protector power to do so. But just a trained eye to look at it, we would just double check it if you would like us to take a look. That's a great question.
Okay. All right. Well, thanks for being here today, everybody. If we can be a resource to you, certainly let us know. I'll send out the recording and the slides afterwards, along with our upcoming webinar information. We have a lot of very interesting and different webinars coming up as we head into the middle of December, and certainly hope to see you on one of those soon and back here at the Elville webinar series. Hope you have a great day, everybody, and a good rest of the week.
Happy holidays.